I have another video that I want to share with you guys because I want to particularly break this down because I found this to be particularly onerous, if you will. So I'm going to take the opportunity, and the reason is because this non-lawyer makes these statements in a very matter-of-fact way. It's about 3 minutes long. So you guys, let's listen to it together.
And this one, ladies and gentlemen,
I'm gonna actually just let him speak through the whole video, and then I'm going to come back and address it. You guys, please just sit back and listen. This gentleman, I don't know him, don't know who he is, but he starts off with man fatally shot in Walmart parking lot following dispute over parking space authority. This is him. Let's listen to the dude with the yellow safety vest on. Somebody type yellow safety vest.
So let's talk about this one, ladies and gentlemen, because again, same narrative, people don't understand how the law works in these types of situations, so we'll go over this. So what I'm going to do for y'all is I'm going to list the penal codes up here in this section of the ones, as we talk about them, of what you're going to be looking for to understand how this is going to apply. So the first one that you're going to be looking for is 790.10. That's the improper exhibition of a firearm in Florida. And yes, the moment that she stepped out of said vehicle, she's displaying her firearm. There's video that's already out there showing this. So she wasn't even provoked or anything like that. She's already doing this. She's in violation. It's a misdemeanor. Next comes because people want to bring this.
All right. So the first mistake that this gentleman made, well, let me say this. This is exactly the kind of internet legal commentary that gets people confused, and sometimes it gets people hurt. And the man sounds so confident because he's throwing statute numbers around, but citing statutes isn't the same thing as understanding the statutes and how they work together. His analysis is wrong from the beginning because he starts with the conclusion she's guilty and then tries to force the law into that conclusion. Okay, so his first mistake is that he uses Florida statute subsection 790.10, improper exhibition of a firearm. He says the moment she stepped out of the vehicle and displayed the firearm, she was automatically, instantaneously in violation of the statute. And that's wrong. Section 790.10 does make it a first-degree misdemeanor to exhibit a firearm in a rude, careless, angry, or threatening manner. But the statute contains a critical exception, not in necessary self-defense, okay? In other words, the statute itself says improper exhibition doesn't apply if the display was part of necessary self-defense. So you can't say she displayed the gun, therefore she's guilty, without first deciding whether she displayed the gun because she reasonably believed she needed to defend herself. He skipped that part, okay? He skipped that exception inside the very statute he cited. And see, this is the danger of this layperson analysis. This is reading half the statute and pretending the other half doesn't exist. He would fail his law school test on criminal procedure if this was the test. Let's keep listening.
This up is we're going to have to go with stand your ground. Now again, in this one, you're mostly going to be looking at 776.013 section 1 part B. Now that's only because people out here are saying, oh, she had a right to stand her ground. So okay, if you do that, fine, and you have to use that one because it was unaliving force that was presented before there. So again, if you're using that, they say that you have to claim self-defense, right, in that part. So then you're going to have to go to 776.012 section 2 in Florida. And nowhere in there, if he's staying so far away, which is almost a body length away, not using a weapon or anything like that, I'm sorry, you fall flat. She is going to be found guilty by that standard. So what is she going to be guilty of? You have two options.
Okay. All right. So again, let's He's still treating displaying or pointing the gun as automatically criminal, and that's the fallacy. Florida law doesn't work that way. Florida self-defense statute 776.012 expressly covers both the use and threatened use of force. Use and threatened use of force. In other words, self-defense can also be the threatened use of force, because displaying a firearm is considered assault. Somebody type assault and battery. We're going to learn something real quick. Assault is placing a person in reasonable apprehension of receiving a battery. A battery is the unlawful touching of the person of another. Now, in some states, they call assault terrorist threats, and they call battery, okay? Or they call assault battery. They mix it up. It comes from the common law, but when you go way back, and the great thing about going to school in Louisiana is that the bar examination is all written. So they literally give you 3 days, 9 tests. They give you some blank paper, and then you have to write it all out, which means you have to do some thorough research. And the only place you can learn the Napoleonic Code is in Louisiana, either at LSU, Southern University, or Tulane. But the bottom line is, it's not a fill in the bubble test. You need to literally read it. And so because of that, we had to go old school. So assault and battery are the proper terms. But the bottom line is, typically displaying a firearm against someone is considered assault. In other words, just pulling it out is a crime, okay? And so this gentleman confuses pulling it out with a crime. But again, the Florida statute protects people who pull their dangerous weapon out in an attempt to protect themselves. That's specifically written in the Florida self-defense statute 776.012, and expressly covers the use of threatened, both the use and threatened use of force. In other words, displaying the firearm. And that matters because pulling or pointing a firearm is threatening. It's threatening the use of deadly force. And under subsection 776.012, a person may be justified in threatening to use deadly force if she reasonably believes it's necessary to prevent an imminent death or great bodily harm, or to prevent imminent commission of forcible felony. In other words, if I think somebody is about to do something bad to me or take my life, I'm gonna pull my pistol out, and the police can't then turn around and arrest me for assault or displaying a deadly weapon. That was self-defense. So that was very thoughtful of the Florida Congress and the governor for putting that into place. So the legal question isn't, did she show the gun? The legal question is, was threatening force reasonable and necessary under the circumstances? Okay, and that's going to be something that the jury would have to determine. Now, the third mistake is that he relies on subsection 776.013, like that's the main statute for this Walmart parking lot case. That's sloppy. That section is mainly about presumptions involving a dwelling, residence, or occupied vehicle. But the cleaner statute for a public Walmart type location confrontation is subsection 776.012, which governs force used in the defense of a person. In a public parking lot, the issue isn't some automatic home or occupied vehicle presumption. Okay, you were wide open in the parking lot. The issue is whether she was in a place where she had a right to be. All right, you can't defend yourself in somebody else's house while you still in the DVD player from 2016. Okay, or something. You can't do that. You're engaged in criminal activity. We don't want to protect crooks and criminals from doing things. And the question is whether she reasonably believed deadly force is necessary to prevent imminent death or great bodily harm. Okay, so I'm gonna let this gentleman finish, and then we're gonna come back and roast him.
And that's literally going to be 782.04, Section 1, Section A, Part 1, right there. Now, if you don't want to use that one, you can go with the next one right here of 782.07, Part 1. That's it. It does not matter what he said, if he threatened her or whatsoever. She used immediately an unaliving weapon, pew-pew, exhibited it, pointed it at him, she's already guilty. She is guilty the moment she has done this right here without being presented with unaliving force. Yeah, she could have felt threatened whatsoever. She could have had her own little personal thing going on up here, but she can't do that with that weapon. And therefore, she's...
Notice just how confident this guy is. He's just so confident. And unfortunately, there are people who would believe this just because he has that Dick Cheney confidence. Dick Cheney would get on the internet and say get on television and say all kind of stuff and have the public just like, yeah, he sounds so confident. He sounds so confident. Somebody type line, y'all call him a laundry room lawyer.
Guilty.
Let's keep going.
I'm sorry. It's just going to be, what do they really want to charge her with? Do they want to hit her with 782.04, or do they want to charge her with 782.07? That's it.
All right. So again, this man's claim, one of the other claims is that because the man was almost a body length away and allegedly had no weapon, the self-defense argument falls flat. I want you to listen to this because that's legally childish. Distance matters, but distance doesn't decide the case by itself. Whether he was advancing matters, whether he was backing away matters, whether she warned him matters, whether he ignored the warning, whether he saw the gun or kept coming, that matters. Whether she was trapped near her vehicle, his size matters, his presumptive strength matters, his age, and sex disparities also matter. The law doesn't say an unarmed person can never cause death or bodily injury to an unarmed. That's not what it says. A person can be seriously injured by being punched, grabbed, shoved, slammed to the pavement, knocked down, choked, stomped, or overpowered. So he had no weapon. It's an important fact, but it's not the whole case. Okay. And the other thing is, and I think one of the most dangerous things that this gentleman said is that, in this whole, video, he says it doesn't matter what he said if he threatened her or whatever. And that's just wrong. Threats absolutely matter. Words alone may not always justify deadly force, but threats combined with movement, especially forward movement, distance closure, refusal to stop, physical disparity, and continued advancement absolutely matter. A threat can show intent, and a warning can show the shooter tried to stop the encounter. Continued movement after a warning can show escalation. And so when he tells the public that threats don't matter, he's telling people to ignore evidence the police, prosecutors, and judges and juries would absolutely consider. Now, here's the thing. He says that she's already guilty. I want you to think about that. She's already guilty. So if she's never charged, now you got a bunch of people running around saying, hey, that's an injustice. You see? She said the moment she pointed the gun without being presented with what he called unaliving force, that's not the law. Florida law doesn't require a person to wait until the other person first uses deadly force. The standard is whether the person reasonably believes deadly force was necessary to prevent death or great bodily harm. That means the person claiming self-defense can be wrong in hindsight. Okay? But the exact level of danger is determined at the moment. And as long as that person reasonably believed that they were in danger of serious bodily injury at that time, that's all that counts. And that's why we say the law of self-defense is imperfect. You don't have to be perfect. All you have to do is be reasonable at the moment. Okay? Because we don't second guess people who are acting in the moment. Were they reasonable? In other words, what would a reasonable person do? Now, this gentleman also jumps straight to 782 subsection 782.4 or murder, and subsection 782.007, which is manslaughter, as if those are the only choices. That's just backwards. Homicide statutes don't answer the justification question by themselves. Murder and manslaughter require unlawful killing. if the shooting is legally justified, then it isn't murder and it isn't manslaughter. You get that? You don't get to skip self-defense and skip immunity and ignore the facts and then say, well, the only question is whether she gets charged with murder or manslaughter. That's not how the criminal law works. You know, this gentleman ignores the Florida statute 776 immunity statute. I talked about it. As I said, Florida law provides immunity for criminal prosecution and civil action when force is used as permitted under the self-defense statute. So in other words, that young lady, the gentleman's daughter, the victim's daughter who was crying, she can't even sue this woman civilly. You can't come back and try to get a civil judgment against her because the shooting was justified. Okay, that's what immunity means in Florida. And that means immunity isn't just something argued to a jury at the end of the trial. It never happens. It can be raised before the trial, and the law enforcement, it may investigate, but it may not arrest unless there's probable cause that the force used was unlawful. And that matters here because based on the public reporting, you all, somebody type you people in the chat room, you people, right? She remained at the scene. She cooperated. She claimed self-defense, and it wasn't immediately arrested while the matter is still under review. That's exactly the kind of procedural posture where immunity and probable cause matter. Now, here's the last thing, and I'm gonna move on. Okay, his certainty, his absoluteness, right? Let me tell you something. No competent lawyer should look at a partial public video, and this is a non-lawyer, okay? But you shouldn't be out here looking at public videos, incomplete facts, right? Saying whether she's gonna be found guilty or not, or innocent for that matter. That's reckless. We don't have the full video. We don't have the audio. We don't have the video statements. We don't have any forensic evidence. We don't have the distance measurements. We don't have the exact timing. We don't have the full sequence before the shot. A serious lawyer would say that the facts may help or hurt depending on what the complete evidence shows. A serious lawyer wouldn't declare guilt from a short clip and a statute number. And that's why this type of layperson, non-lawyer, that type of commentary is dangerous because you all, somebody type you people will believe it. See, he's not just giving an opinion. He's presenting wrong legal conclusions as education. He's teaching people that displaying a firearm automatically makes them guilty. That threats don't matter, and that unarmed aggressor can never justify deadly force, and that prosecutors only have two options. That's legally flavored misinformation, and legally flavored misinformation is worse than ordinary ignorance because it sounds smart enough to fool people who don't know the law.